Our speakers will be helping us better understand what is going on at the southern border. So please join me in welcoming Ms. Andrade and Mr. Stein.
Hi, everyone. Thanks for being here. There's only one mic, so we're going to do a little back and forth, and hopefully it won't be too disruptive for you. But I guess as a preliminary introduction, is both Ben and I have spent a lot of time at the border, both recently and in years past. I most recently was there last summer in El Paso, and previous to that, we had a number of trips beginning in 2014, both to New Mexico when family detention began, and later into another place called Dilley, Texas, where it continues to be the largest family detention center. And Ben, on the other hand, before he came to work here in Idaho, spent quite a bit of time actually working on the border. So if you want to talk a little bit about your experience before we get started.
Yeah. So before I came to Idaho, I worked in Harlingen on the U.S.-Mexico border in southern Texas. Not working as much with asylum seekers, mostly with people for U visas, which are victims of domestic violence, being able to get a visa. And then since, as Maria talked about, we've made several trips to the border. My most recent trip was to Dilley, Texas, which is the largest family detention center in the United States. And so that's our experience.
Okay. Great. So we wanted to make sure that you knew that part of what we're sharing with you is actual, observations of what we've seen. Of course, we're keeping up on the news as well, and it's a lot of the reason why we want to be here, and a lot of the reason why part of the mission of Immigrant Justice Idaho is education. Because as you might have seen in the media, part of the portrayal you might think of the average asylum seeker is a gang member in the form of a professional wrestler who steals kids not their own as a guise to let themselves into the border, into the United States, intent on killing Americans. Now, obviously, this is an exaggeration, except for it's made up of allegations that are not exaggerations. Over the course of the last couple of years, but particularly in the last 3, 6, 9 months, there have been a lot of characterizations, both from the executive department, from agency heads, and others, making broad stereotypes and accusations about who are the people that are coming to the United States in these days. So what we're going to do is talk about who's coming now, how is it different than before, why do we think that's happening, and who's done what about it, right? Lawsuits have been filed, things have stopped and started. So one of the things we were laughing about is, what's going on the southern border is changing by minute. We were preparing last night some of the things, and we had just gotten notice from a friend that a lawsuit had been settled immediately, like hours before. So this stuff is changing all the time. So our experience, as the slide before you indicates, is that what we see are loving parents who are fleeing violence and making really what they've come to determine is a rational choice based on the circumstances that they are experiencing. It's very hard for us to imagine, I think, what you must be going through in order to think that it is a rational choice to come to the United States without knowing if you're going to be entered with a small child, right? Very severe kind of decision to make. So without getting into like story after story of what we've heard, our experience in talking to families over and over and over are these were choices made by loving parents that came here thinking this was the best option that was available to them. So the people we see look a little bit more like this, kids, parents, family units. And the reason that people are coming primarily are sort of like, you could talk about it in these boxes. And we've had cases from that folks that have made it up from the border in Idaho that fall in nearly every one of these categories in terms of the why. Why are they coming here? So the gang-based threat of violence. Now, people think a lot of times what we're talking about is, oh, well, it must be like really dangerous there and people don't want to go outside. I mean, that's certainly true, but I think what's happening is a little bit more precise and has a lot more to do with kids. If you want to talk about some of the gang-based threats.
Yeah, so I mean, much of these groups are people are coming directly to protect their children. A common story that I would often see is, a child there's a child's being threatened by gang recruitment. If he doesn't join the gang, they're gonna forcibly make him join the gang, and the mom, to protect the child, will flee to the United States. These are the common groups, and then there's been lots of people being targeted based on their sexual orientation. We saw a lot of people being targeted based on being indigenous or based on their ethnicity. I can say that when I went to the border, I went with a group of attorneys that had not done this kind of law. And when they went, they were just shocked at how everyone was scared for many of the same reasons, because of what they'd heard on the news before they came, that many of these people were not legitimate asylum seekers. And so I can say from firsthand, the people that go down there have been shocked to see just the reasons that people are fleeing. So.
And sort of 2 points to make here. One is, when you have in your mind what a gang is, I want to give you a different idea. First of all, El Salvador is a country the size of, I want to say Kentucky. It might be smaller than that. It's smaller than that, I'm being told. There are swaths of parts of these countries where you cannot engage in business, you cannot ride a bus, you cannot come in and out of your little town without somebody associated with the gang knowing about it. So one of the really common jobs is for a younger person. They are outposted around the perimeter of the 3 or 4 roads that lead into the town. When you go into the town, someone is there to be like, who are you? Who are you connected to? What is your business here? And they control, and we have made, and people have made successful arguments that the gangs are not some side criminality group, but really they have risen in certain places to be what we would call a second sovereign. Okay? What I mean by that is somebody who has basically taken the place of the government, because they have their own rules, they are known to everybody. They have a way of enforcing those rules that are known to people. They carry out those rules with impunity, and there are very, very, very severe consequences and punishments for disobeying, being disloyal to the gang element. And they are now not even called gangs in U.S. Department of State literature and other literature. They've been designated transnational criminal organizations. And the reason for that is because they have tentacles and connections to other entities in other countries. So we're not talking about, we're not talking about 5 people wearing the same color shirt hanging out on a street corner, selling like dime bags, okay? That's not what's happening. What's happening is like people are enforcing a whole system of rule, deciding who gets to run a store, who gets to go to school, who gets to go to college, who gets to be my girlfriend, my boyfriend, and what the consequences are if you don't do that. The other thing I want to point out is that when we say bona fide asylum seeker, so what we're talking about is people have a legitimate, they're running from something, okay? Later, we're going to show you a couple of the constructs for asylum law. Like, asylum law only recognizes people, provides protection for people that have been persecuted or fear persecution for certain reasons, okay? So we have plenty of people who are very, very scared for very good reason to be in their home country, but the reason they're scared and the person they're scared of is not something that we protect in asylum law. So when we talk about people are bona fide asylum seekers, these are people who are coming here not because they just want to buy a house in Meridian and get a new truck and have an America. These are people who feel they must flee because of some circumstance in their home country. Okay, the next one is yours. All right, so first point here is really kind of what's brought us to having this discussion.
So there is more people arriving at the border now than there has been in recent years. However, the characterization we're seeing in the news, I think, is often not correct. The statistics will show that it's more family units than there has been. And as a result, we're seeing more family units, and there's also more migrant children entering alone. So when I talk about they're unaccompanied minors, that means they're arriving without any kind of parent or without a parent. And in general, right now, the United States has more migrant children in detention than ever before in its history. There's a lot of factors to this. Not only that there's more migrant children, it's taking longer for unaccompanied minors to be released from Office of Refugee Resettlement custody, because that's the first thing that happens. To characterize the people that are coming now, it's more it's more families and children. And then with regards to whether it's an invasion, as has been said by the president, we would point out that of the undocumented people in the United States, 42% of them entered on a visa and overstayed that visa, which could be people on tourist visas. So these are people that would not be entering the United States unlawfully. They would have entered with a visa and left. So that connection to undocumented people in the United States to what's been called an invasion, it doesn't make sense factually. So that's the main points of that.
And you probably won't be able to read this, but this is a chart from fiscal year 14 to 19. The one observation, so the top line is the red line, right? And that it's starting at 60,000 apprehensions, and the blue line, the lowest one, or the orange one maybe, is a little more than 30. But the thing to also note is, like, right now, spring, right? It's sort of a time, if you're gonna cross, where you think maybe you can make it across without dying in the desert, if that's your intention. So that's always been, you can tell, always kind of been a time, January, March, April. So when you hear the numbers, they're talking about numbers of apprehensions. And because families are coming, you're getting like one unit coming with 5 people, which is different than maybe 10 years ago, which we'll talk about in a moment. So was there anything else on that one? Okay.
I can just keep going.
So I'll do the first one. So look, if we look at like what's happening now and what happened like 10 or 15 years ago. So it used to be that a lot of the border crossers were coming from Mexico, and they were single men looking to work. And because the border is right there, we don't have, we the United States is able to like, be like, you don't have documents? Okay, see you later. You know, they just cross over the border right away. It's fast, it's a single man. There's no issue with kids. There's no issue about somebody, what we would call asserting a fear. So what I'm talking about, the last one is current day, invoking a credible fear process, which we'll explain, meaning that people are asserting that I'm scared to return, and I want to tell you why. And the credible fear process is the process that is the first level screening, so that somebody from the government could hear that story and be like, okay, maybe, probably, or no way is what you're telling me ever going to be an asylum claim. So that's the first level screening. And then,
Yeah. So as I mentioned, and just to go with that screening, so that also, it's a credible fear process. It means that when someone claims that they're scared, it's not like they're automatically allowed into the United States. They have to go through a process to determine whether that fear is credible. Okay, so then, as we said, there's more unaccompanied minors. So there's a process where the government, if someone's from Mexico, they can swiftly return them to Mexico, either through what's called a voluntary return or through what's like an expedited removal process. But the thing is, when people are coming from non-contiguous countries, then those people cannot be swiftly returned through a voluntary return. So like when you have someone coming from Guatemala or Honduras or El Salvador, they can't just be swiftly returned back to their country like that.
okay, and then this is the other thing that you're not hearing about that really you need to know is the push is part of the mix of why you see people under a bridge, why you see lines of people waiting at the border, why you're seeing these graphic images. Because in the pretty much now, current nationwide policies that exist are one big change is everyone is a priority for arrest and removal. It used to be that we had a memo called the prosecutorial discretion memo, which basically instructed people in a position to bring immigration charges to evaluate the situation and decide, is this really someone that it's worth me spending my resources on to try and remove them? So if you had serious criminal convictions or something like that, you know, you would be higher priority. But if you were a non-driving grandmother who hung out and just like was at Walmart with their niece and got picked up, you wouldn't probably, I mean, the chances are you can make a pretty good case that it wasn't really worth the resources to remove that person. Well, that changed. Okay, so everybody's a priority now. That means there's more arrests, combined with the fact that there is a presumption that we will detain everyone. Used to be that even the people were being prosecuted, Immigration and Customs Enforcement, before packaging like their luggage and sending them off to an immigration detention center to go talk to a judge to ask to be released, a process that can take a month, 2 months, 3 months, that the local immigration officers were much more willing and had were encouraged to, at that moment, make a decision about whether this person is a flight risk, like, are they really going to show up for their court? Yeah, they probably will, they have small kids. Or are they really dangerous to the community? Nah, they're not dangerous. You know, they stole that hat or that loaf of bread because they were hungry. But anyway, more people were getting released because case-by-case determinations were being made. That's not happening anymore, at least not nearly at the rates that it had before, leading to more people being detained, right? Taking up more beds, putting more cases before immigration judges who will hear. So you're going to plead your case now to an immigration judge, not just to the immigration agent. With the fact that there's no new money to hire judges, and I'll tell you, 5 years ago, 10 years ago, there still weren't enough judges, and there aren't. So it was compounding that process. At least a while ago, judges also could decide, like if Ben was picked up, but he's, in the process to legalize through another route, whether through that U visa we talked about earlier or a family route, but he also got picked up by ICE, well, the judge could be like, you know what, looks like you're going to be approved in 6 months, so why are we bothering with this case? We'll put you back on we'll close your case for the purposes of moving forward, put you on the shelf, let you go through the other process, and see if you become legal, and if you do, we'll close your immigration case. Well, that authority has been taken away from the judges, meaning all of the cases now are going. So we've cut the judges' ability to manage their cases. And then the other things are like, what are the reasons, which we don't have time to get in here exactly, like what are the reasons for the breakdown of civil society and governance, good governance, right, in the Central American countries that are primarily the ones from which folks are coming, the Northern Triangle, which we refer to as Honduras, Guatemala, and El Salvador. And so in the Obama administration, there was quite a big aid package that was sent. And we had just, you probably heard reported that the Department of State has announced that it's going to suspend delivery of an aid package to Central America, like as a penalty, purportedly, for not doing more to keep their folks from coming to the US. And there was a wall. There has been a wall. Wall has been being built for a long time. But those are things to keep in mind because, policy decisions to detain people are part of the reason you hear this thing later that's like, oh, we're running out of beds, we have no more space. You're like, well, yeah, you could see that because more people are being detained.
Right. Or why someone's asylum case might take years to be adjudicated.
Right.
Because what you're hearing in the news, right, is if you let someone in, then they're going to be here for years. And part of the reason is because their case is going to take several years because they're not prioritizing. If you're referring everyone to proceedings and you're not administratively closing or terminating proceedings, the backlog is going to keep growing. And the people's cases could go stale. They might not, and they can't be adjudicated in a swift manner. So, okay. So moving on with some just asylum law basics, because we're going to get more into the history of asylum law and a little more into the weeds of some of these decisions that have been issued. So, the main thing to always emphasize when we talk about asylum law is refugees and asylees have the same definition under the Convention Against Torture, under the Geneva Convention. Refugee is a person with a well-founded fear of persecution based on either their opinion, religion, nationality, race, or membership in a particular social group. So that's why when we say people that are coming up, they will have what I would believe to be a real threat on their life. But if they can't make the case that they fit within one of these groups, they're not going to qualify for asylum. But so the main difference between a refugee and an asylee is the same international definition. The difference is where a refugee is processed abroad and enters the United States as a refugee. An asylee, the only way that they can get asylum status is by presenting themselves at the border or entering the United States and applying from within.
And okay, you were buzzed by that, so
just
just want to make this point because people always talk about why didn't you come legally or why didn't you apply back home? Like, there is no place to apply. There is no place to apply. And so 2 ways to apply: coming to the border and applying at the border, coming to the United States, coming into the United States, and then applying affirmatively, meaning packaging up your application and filing it to an office that makes those determinations. I'm going to skip this one. That was
Yeah,
a
you should
duplicate.
go to
Okay,
that.
so let's go.
Okay, so what happens then when someone, if they win asylum, well, they can get work authorization. There's a pathway to lawful permanent residence, which is the first step before becoming a citizen. As lawful permanent residents, they can get the benefits that other lawful permanent residents can receive. And they have the ability to then try to bring their children or their spouses from the different country or as part of their application as derivatives. I think a notable thing here is that children cannot include their parents as derivatives. That is not
Right.
a process that happens. So like a child can't come here and win asylum and then ask for their parents. The parents are not included as derivatives.
That makes sense? Okay. Okay, so I'm going to go through this pretty quickly. So here are the elements. This is the only thing you got to prove to win asylum. You have to say that I either suffered past persecution in the past, we'll talk about what persecution means, or I have a well-founded, meaning well-founded fear of future persecution, meaning I really am scared, and there really is an objective possibility based on the country conditions and whatever happened to me that that's going to happen. To a 1 in 10 chance, I have to show. It's 10% likely that that's going to happen to me. And then I have to show the nexus point up there is what we're talking about, fitting in the group. The reason that I'm going to be harmed. And this is hard, right? Because people that harm others, sometimes they tell you why, but sometimes they don't. So, if it's really easy, well, I am of a Christian faith living in a place that's dominated by a different religion, and they continually burn down my house or burn down the house of other people that share my religion. That's a pretty straightforward one. There's no other reason for the persecution. Religion's on the list. I come in. Or at least I've met the nexus ground. Then you have to show that the state, even if all that's going to happen, that the government either doesn't want to protect me or they just can't. Like they just can't. They don't have the money, they don't have the resources, they don't, they just can't protect me. And I have to show that no other place that I can move to in that country is safe for me. Okay? Easier in small countries, harder in big countries, obviously, right? And then you have to show you don't have a bar. So people can be barred from asylum. There's something else, we're not going to talk about it now, that prevents the U.S. government from returning people who are like 51% likely to be tortured. So that's out there, you should know. But you can be, if you can't meet that high standard and you have certain criminal convictions, you can't get asylum. You just can't get it. You have to then show much higher risk of suffering that persecution that we talked about. And so this is a laundry list of things that qualify as persecution: forced child marriage, prostitution, servitude, serious physical harm. I'm not going to go through all of those. And then here's another slide, just talks about how you have to really, you don't have to say it's the only reason that I'm being harmed is my religion, but it is a central reason. It is one of the central reasons. So lots of people are, well, you got harmed, but that guy was also like your coworker, and you got the raise, and they didn't get the raise, and so maybe the reason that they did that to you was really because they were mad and jealous. Well, as long as I can say, yeah, that's probably part of the reason, but it's not one of the central reasons. That's my obligation as the asylum seeker. So what you can tell about the complexity about this, it is hard to win this kind of case alone in detention without a lawyer when you just crossed the border and you maybe haven't eaten and you have a sick child and you've had a hard journey. So for the next I'm sorry, go ahead.
And one more thing about that too is one requirement that is often lost when people come in is that in order to timely file, you have to file within 1 year of entering the United States. So if someone's been here for over a year and they were unaware of this requirement, which we're seeing a lot, there's been class actions saying that immigration authorities have not provided notice to people as they're released from detention. If you don't file within a year, you could be barred from asylum just on that basis. And filing is not an easy thing. We have to file with the government, with the court. It's really hard for someone without an attorney to understand what that means, that they have to file within a year, even if they're told that they have to do that, which sometimes they're not.
Okay, so we're up at 2 o'clock, so let's just, so the next thing we want to talk about is why do we even let in asylum seekers at all, right? So we want to talk about, we're going to get into what the challenges have been, but it's important to keep in mind, okay, what does the law require we do, right? Why does it require that we even have, a protection system? And on the ground in the weeds, how does the way we're doing it now compare to the way we've done it in the past? So we're going to go into a little bit of history.
Yeah. So just as a historical perspective, U.S. asylum law is derived from international agreements that came into place after World War II. Prior to World War II, there was no definition or distinction between people that were fleeing persecution or just seeking to enter the country for another reason. So after, just as a quick, after World War I, the United States became increasingly isolationist and started having strict quotas in the number of nations. So at the same time, people couldn't seek refugee status, and there was also a limit on the number of visas that could be issued. So like, for example, an example of a quota was in Romania, where there were 500,000 Jewish people. The quota was 377 people. So if you weren't one of those 377 people, assuming that quota was even met, then you would not be able to come to the United States and flee persecution. And then there was, because of like the political climate, there were additional administrative restrictions that were then placed on even these 377 people, where they would have to show more good moral character or increased financial value to the United States. So really, there was no way for a lot of these people to come to the United States. And I think it's important to think about when you're thinking about what's currently happening and restrictions that are being placed on asylum seekers and how historically we've been here before. Yep. And so then, as I said, there was no refugee designation before World War II. After World War II was the first time that there became refugees under international law. The United Nations Refugee Convention defined refugees. It was that definition that I read earlier, that someone that based on a particular social group, race, religion, nationality, or political opinion. The United States did not sign on to the 1951 United Nations Refugee Convention. This convention, 1951, only applied to people that became refugees as a result of what had happened in Europe, only Europe, before January 1st, 1951. And the obligations to these host nations were, they were obligated to provide refugees the right to work, housing, education, freedom of movement, and not to punish someone for illegally entering the country to seek refugee status. Okay, so then in 1967, there was the UN protocol relating to the status of refugees, which expanded protections to people fleeing persecution worldwide on a permanent basis, so long as they could show that they met the definition of a refugee. And the United States was a signatory to that. But it's still, in order to actually put these obligations into compliance with US law, in 1980, the United States enacted the Refugee Act. And so the Refugee Act was, they were going to honor the obligations of the UN protocol, and it created that if someone came to the United States and could show that they were a refugee under international law, which is asylum, that they were entitled to these protections under the UN protocol.
Okay. And then I just want to, this is really, like, if you ever Google, like, the journey, like, the voyage of the St. Louis, this is a map of where this boat, carrying a number of people fleeing the Holocaust, traveled, trying to let somebody, asking to be allowed to pull into, I guess, a port or so that people could go there, so they could flee persecution. And they were denied multiple times from Canada, from the United States. And so they had to go and turn around and go back and try and find another place. And ultimately, they were finally permitted, it was called the St. Louis. They were allowed to permit to land in Western European countries rather than return to Nazi Germany. But 254 of those passengers were killed in the Holocaust because they had to go back for a moment before they re-embarked. And this was the lesson, right? This is what is the underpinning of what we never wanted to see happen again. It's like one of the biggest black marks on what we've done, in addition to some internment camps and some other things. And where we look back at this event happening now in 10 years will be telling. But I think about this boat, and I think about how everybody now, if they were in that moment, would have seen the travesty and the moral, vacancy that we experienced and we didn't have in our immigration policies at the time. So Ben is next going to talk about this other thing. The Refugee Act leads into something, then some folks might have heard of IRA, which was a whole bunch of stuff that passed under Clinton. Long story short, it had lots of provisions that dealt with immigration. One of them was to say, we're now going to let immigration officers at the border enter deportation orders against people. We used to not do that. And so the international community was like, hey, you know what? If you're going to let people come to the border, talk to an immigration officer, not let a lawyer in, which we're not have a judge make that decision, which they don't, and it's just going to be 2 immigration agents, then you have to have a way to make sure that we're not turning around the boat again, right? That we're not sending people back to their death. And so they carved out the credible fear process that we mentioned earlier. So
yeah, that we're not repeating the same errors, but also that it's lawful, because the law right now is that we have to protect people in accordance with the UN protocol. And so when the Congress enacted this expedited removal procedure, the question was, well, how are you going to be able to tell the difference between those that are in fear for their lives and those that are just trying to enter the United States? And so the way that the U.S. was able to assure the UN and just comply with the law generally is that they enacted this credible fear interview process. The credible fear interview process means that when someone enters the United States and is subject to this expedited removal, if they claim a fear of return, then they have to have an interview with an asylum officer, which is supposed to take place within 10 days. Don't quote me on that one. But it's supposed to happen immediately. And the reason it's supposed to happen immediately is because it's supposed to comply with the goal of expedited removal, which is to remove people quickly. So when you hear the government saying, or the president saying that they just say, I'm scared, and then they get let, like what's happening is if you claim a fear of return, then you get an interview with an asylum officer. You have to show an asylum officer that you have a significant chance of winning of showing that you qualify for asylum. If you can show that asylum officer that, then you get put in regular immigration court proceedings, at which point you then have to meet a much higher burden of showing an immigration judge that you qualify under the asylum law. So this credible fear process is a basic, lower threshold process that we enacted to make sure that we were complying with our international law and also our domestic law that it purports to comply with international law.
Okay, so that was the regular way that things would happen, and people would just, they would either present themselves at a port of entry and they'd be taken into an office and, in a little kind of processing center for less than a day probably, and then arranged to be held in detention while they do the credible fear process, which would happen pretty quick. And if you passed, then they would do a bond determination, and you could, go to wherever your family or wherever you want to live and wait for your court notice for your final court hearing. And so now, right, we're seeing that people aren't being let in. There's lines of people outside. Supposedly they don't have enough people to to carry out the interviews. And so let's look at some of the specific reasons, specific differences now after, I would say after 2017. So, right, remember that it's taking a long time because now we're detaining everybody. I mean, it could be, and officers at the border did have authority in certain instances to let people enter who didn't do the credible fear processing yet. And there could have been a lot of reasons for that, humanitarian, or maybe they showed they had really strong ties, or they already had contact with an attorney because attorney represented individuals have much higher reliable rates of appearance at their hearings. So there's that. And then, right, we had zero tolerance, which leading to family separation. So let's spend a minute there. What this was about was a policy choice by the government to say, if you enter the country unlawfully, we are now going to bring a criminal prosecution against you for the unlawful entry, which is a federal misdemeanor, okay? Very rarely charged as an initial charge. That's just really uncommon. It wasn't something that was charged that much. And because of the charge, then they were saying, and we're going to detain you because of the criminal charge, not civilly in the Civil Immigration Detention Center. Criminally, you're going to go to the Bureau of Prisons now. And guess what happens in the Bureau of Prisons? You are not allowed to have your children with you. Sorry, not my fault. I guess I have to take away your child. So that is when you heard the DHS secretary saying, like, the law requires me to separate them. It does if you make the policy choice first to prosecute everybody criminally. Okay? So that was zero tolerance that's the name of doing the criminal prosecutions leading to the family separation. Okay? The other thing and that was subject to a lawsuit we'll talk about later, which then they tried to restrict asylum applicants to only go to a port of entry. So ports of entries, right, San Ysidro's one, Tecate, Ciudad Juarez, El Paso, but people cross, and they cross unlawfully. They cross, like, not, when I say unlawfully, meaning they're not going through a port of entry. So, but the law says you may apply, regardless of your any, they use the word alien, which I don't love, any alien, irrespective of status, may apply. Meaning regardless of whether you have a visa, you don't have a visa. So folks who entered the United States, make it to our office, they're within a year and they want to apply for asylum, law totally permits that. But what the executive was trying to do is say, no, only people who go to the ports of entry get to apply. Well, that was slapped down pretty quickly because the statute was very, very clear about asylum eligibility not being restricted to only people who go to the ports of entry. And quite frankly, now what we're seeing after making people wait so long and returning people to wait for their hearings, not in the United States, right, but not letting people in once they pass the credible fear to wait for their hearing in the US, but sending them back to Mexico, is like creating an incentive for people to just be like, why am I even presenting myself at the port of entry at all? Like, if that's what's going to happen, right? If I could enter, I mean, there's other horrible things that come with entering, through a desert, but there's consequences to making a decision like that, and it's no longer in effect.
Yeah, and because at the port of entry, they're only processing a certain amount of people, so people are being forced to wait very long periods in often dangerous cities, and so that's it's a decision to only allow a certain amount of people through a port of entry. Unfortunately, it pushes people to maybe take a drastic choice to go and try to enter unlawfully somewhere else.
So as a result, people are waiting in these long lines. And at first, it was just like a day or 1 hour, 24 hours in a day at the line. And then people started sleeping overnight at the outside to try and get into the port of entry, and then several nights. And so these are like the people that are waiting. These are family units. These are small kids. They're under, they're in inclement weather, setting up makeshift tarps so that they can wait. People are right now penned under this overpass that you're looking at between El Paso and Ciudad Juarez, and they're waiting underneath there. I'm just going to go quickly to that like this. There's razor wire. They're behind these fences. And what happened is the migrants themselves created this system where they were like, we're going to make this orderly. They put together this book of names. And so like somebody is in charge. They're the holder of the book that day. And they're like, you're here first, you're next, what's your name? They give you a number, right? A number that looks like that gets written on your arm. You can see the ladies with the baby that are like trying to get on the book. See, they're talking to the keeper of the book. CBP had started telling people, that's Customs and Border Patrol, telling people that not even to come over. So they were going over the bridge and being like, yeah, you can't apply here, you can't apply here. That was something that was being documented at the borders through affidavits. And waits turn into months, and the number system is still going on until we get to the point that we are now, that people are being told, even if you pass, so we're going to give you this number, you're going to wait forever first to get your number. You're going to get your number, and then you have to go 40 miles, 60 miles away. Maybe it's like 40 miles, I think, from the border where in Mexico, where from Tijuana, which is the border I'm most familiar with, to go wait maybe a month, I don't know, maybe 2 months. And then we're going to call you when it's your time to come back and get processed. And then when you get processed, if you pass your credible fear, we're going to send you back, and we'll let you know when your hearing is. I mean, it is I mean, what happens? People are like, I'm not doing that. I'm not trusting like lady I don't know with the book to tell me. So a lot of people are just staying. They're just going to stay there. They're like, I've waited. I've done all this. I'm not going to like lose my place in line, right? It's hardly a good system. All right. So
You already did that.
I think we did this one already. Yes.
Yeah.
So I just want to. So this is why the external factors of detention and who's coming are important to keep in mind. So now we want to get right into what are the real changes in border policies. And so we tried to make a list of what we thought were the big ones. We've talked about the first two, detention, separation. The detaining family units was starting mostly in 2014, right? So under a different administration. Family separation, we know, started this last summer, and then there was a decision by the Attorney General purporting to just to classify folks that were seeking asylum based on gang-related violence or domestic-related violence that suddenly was not going to be valid anymore. Metering and funneling, what we mean about that is saying we're only letting in 20 people today. It's metering, right? Saying like, and tomorrow maybe we'll let in 10. Funneling being like, oh, you made it all the way to San Ysidro, sorry. You really need to go to Mexicali and go apply there. So they've been trying to move where people could apply. And the last big one is the remain in Mexico, the one even after you wait, you get your number, you do your interview, you pass, and then you get sent back to Mexico. So we're going to take a look at each of these, and I'd like you to thinking about it, whether it's today or tomorrow, is, assuming these policies are lawful. We'll see what judges have had to say about them. But assuming they're lawful, I would like to challenge people to think about, are these ones that we think we ought to be seeking? Do the policies actually achieve the goal, any really rational goal or asserted goal? Do they feel offensive to either personal values or social values or shared values? Is there a social cost, or international reputation cost, any other kinds of costs to seeking those policies? So I'm going to just say quick words about family detention. So here's the Family Detention Center in Dilley, Texas. It's a, 2,000-bed facility? 2,000?
2,400?
2,400, yeah. And this was built after this facility, the Artesia, New Mexico facility, was closed. That was the one that was open in the July of 2014. And this was like one of the only days maybe I smiled down there. Was there was a protest that the folks on the inside wrote letters to us from the outside and said that they wanted people to know if anybody knew that they were there, because Artesia is a really small little town. It's 40 miles from Roswell, so it's really tiny. And so the upper picture, the one to the left, is over the fence into the facilities, which is that trailer area, and some of the folks, the women and kids that are saying hello, and then the other photo is us at a protest and talking back to them and waving hello. So let's go to that. Lawsuits.
Lawsuits.
So we're going to spend a little time here. I think we have, we're good on time. I'll do the first two quickly. Okay, so family detention and family separation. So the family detention Artesia situation was that was set up in super fast. They didn't know where to put folks. It was a federal training center. They would train all kinds of different federal employees who had law enforcement related duties there. And they clearly weren't anticipating having women and kids and attorneys show up. But the conditions were horrible. The conditions, they did not contemplate having kids there, and lawyers there. So they were crowded and not private, and there was not enough medical care. Kids were getting really sick. And so there was a condition lawsuit that was filed there, but before it was resolved, that place closed. So there were a lot of allegations about the horrible conditions. The way it's related to family separation and that Reno case above there. So Reno v. Flores is a case that was had to do with detaining migrant children. And there was a settlement agreement entered into in 1997. And under the terms of that settlement agreement, there were agreements that the government would hold children for not more than 20 days. But first, they ought to be making continuous efforts to make sure that the children are placed in the the most beneficial, least harmful environment, recognizing that there's emotional harm and physical harm to children in detention. And so the most they could keep people for was 20 days. And it pops up again and again, and you hear Flores talked about again and again, because when the families then were being detained with the kids, the question became, well, does Flores cover the family unit, because in order to effectuate the rights of the child, we need to have the parent with them? Or do we get to say to them, okay, your kid gets to go, but you get to stay here? Is that a workable solution? Because then the child would go to the Office of Refugee Resettlement. They're like the orphanage for all the migrant children, where they would sit there, we know now, for a long time before they're released. And there's been horrible reports about treatment of kids in Office of Refugee Resettlement. And the ORR has said, unabashedly, we are not prepared. We don't have the staff. We don't have the oversight to take in more folks. And those of us who went down and tried to deal with ORR and went down to the border and talked to them, it's such a dysfunctional system. I mean, they don't have the infrastructure. So so that's why you hear Flores talked about, and Flores is still good law. The government has been making representations in court almost any time it's relevant that Flores has to be revisited, that Flores is the problem. And it just bears repeating that this was a voluntary agreement entered into by the U.S. government at a time when they had lawyers, they had options, and they entered into the agreement, and that it's valid as of today.
The judge's name is not Flores.
The judge's name is not Flores. You might have heard that mistake. But so family separation was stopped through a case called Ms. L versus ICE, and that was an ACLU case, and luckily that was kind of before we saw a bigger wave. But there is, in all of these cases, a preliminary injunction, meaning there's a court order saying that they cannot continue to enforce those policies. So those are the top two. I'll let you handle the rest of those.
So now this decision that probably a lot of people heard about, where it was reported that that Sessions had sought to end domestic violence-based asylum claims. So let me give you a little more context. So if you remember at the beginning, we talked about the main reasons that people are fleeing from Central America that we see. And a lot of them have to do with gangs or domestic violence. And so when we went down to Artesia, where they were first trying to hold people, with attorneys, we won the first 10 or
15.
Was it 15? We won the first 15 cases, showing that they were actually valid asylum seekers with valid claims under the law. And so the way that the court system works is immigration courts are within, they're an administrative agency. So above the administrative agency decisions are circuit court decisions. And then above the circuit court are Supreme Court decisions. So when we were making our argument, we were relying on administrative decisions, but we were really relying a lot on our circuit court arguments, because those are controlling of immigration courts. And so what Attorney General, then Attorney General Jeff Sessions did on June 11th is, so Jeff Sessions is, as the Attorney General, was able to certify a case to himself. And he certified this case.
Wait, what does that mean?
Sorry. Certify a case to yourself means you're going to take the decision out of the authority of the Board of Immigration Appeals, because the Attorney General is, you say the boss of the,
Yeah.
He is the boss of the Attorney.
Without anybody asking him to?
Well, yes, without,
Okay.
and with no appeal to him.
Right.
He on his own accord, whatever, and he took the case up by himself. And this case that he took up was called AB. And in matter of AB, the Attorney General overruled a case called matter of ARCG, which was a case that we had relied on and was good law for 3-4 years at least, based on circuit court law also. And he said that generally claims by, I'm going to say non-citizens, pertaining to domestic violence or gang violence perpetrated by non-governmental actors will not qualify for asylum. And so that's what he said in matter of AB, and directly overruled the previous Board of Immigration case law. You can see that was pretty targeted at the people that we have been winning cases for, and the people that we see coming to the border. And then on July 11th, they issued this policy memorandum to the asylum officers saying that they are supposed to apply this guidance to anyone that's seeking a credible fear interview. So I was actually in Dilley, Texas, when this memorandum came out, and it was horrible for everyone. But the main goal, obviously, was to try to eliminate these claims that were viable claims under longstanding law, to eliminate the number of asylum seekers that could win. Then it was appealed, there was groups filed in district court saying that this was unlawful in the District Court of Columbia in D.C. That judge issued an injunction holding that rule that categorically against domestic violence and gang claims was contrary to circuit court law. Remember, that's above the law of the Board of Immigration Appeals. And then, so based on that, the decision was held to be arbitrary and capricious, and it was ordered that in future asylum officer interviews that they could not use this new case. And it was ordered that people that had been deported had gotten a negative decision based on this interpretation of asylum law, where the government was ordered to bring them back. It's unclear how it's going to work out in immigration court, but like I said, I think that ordinary principles of law will show that the circuit court law is what is controlling, and that's what we rely on when we make our arguments.
I mean, just yesterday I was writing a brief with another colleague of mine, and we, because that memorandum never applied and therefore to immigration judges, and therefore that revocation of it, doesn't apply to immigration judges, the judges are still applying matter of AB as controlling, and our job is to say, it's controlling, but until the Court of Appeals says that it's controlling because it's directly in conflict with prior precedents from the Ninth Circuit Court of Appeals, it's error to follow it. So it could be that we're still waiting for a case that's going to work its way to the Ninth Circuit, and the question becomes for the Ninth Circuit, is the Attorney General's legal reasoning in that case worthy of what we call deference, basically meaning, is it make sense, or is it contrary to law, and now are we going to adopt it and say all of our precedents contrary go away? That still hasn't happened. So, but we're having to confront in our briefing the case, even though this decision was issued and the injunction applies to the adjudicators on the ground. Because remember, adjudicators that are doing the credible fear interviews, they're not judges. They are officers of a government agency. Well, so the judges, they're not officers, they're judges. But it's a very different sort of questioning and investigation and evaluation of the facts, I would say, than you get in a courtroom, than you get in a high pressure sort of really fast screening process that happens at the border.
Yeah. So the point of that is, it's a policy decision, but using the law as a means to try to shape policy towards Central American asylum seekers, in my opinion. The next thing, which Maria already touched on, was this, people refer to it as the asylum ban, saying that people that could only apply for asylum if they came through a port of entry, as that was pretty swiftly struck down by the District Court of California. So as Maria said, the actual Immigration and Nationality Act, which is the law that was created by Congress, says any alien who is physically present, who arrives at the United States, whether or not at a designated port of entry, may apply for asylum. So the actual proclamation that the government tried to make directly conflicted with words of the statute, which is Congress's stated intent. The government appealed to the Ninth, so there's an injunction issued saying, you can't apply this anywhere. People can still keep seeking asylum as they had in the past. And so the government appealed the injunction to the Ninth Circuit. The Ninth Circuit denied the government's stay, meaning the injunction's still in place. The government then appealed to the Supreme Court. The Supreme Court declined to hear the case. So this has worked its way through the system. This injunction was found to be illegal to say that people could only enter the United States and claim asylum through a port of entry.
And I think we'll take, just because there are some folks getting credits out here. So the injunction, just so that we're clear about, an injunction usually relates to, it's a preliminary thing. It's like when you say, like, that policy really hurts a lot of people and it hurts them right now. And so I'm going to go to court and say, look, maybe the government's going to someday show that that policy is lawful. But for now, I think that I have enough evidence on my side to show it's not. And my client is the one who's going to be severely harmed. And it's no harm to the government if it turns out I'm wrong. But what we call it's a balance of hardship. So if I can show, look, Judge, what you should do is, while the case is being litigated about whether or not it's actually lawful, let's not let it go into effect because the consequences would be so harsh to my clients, and it's really no big deal, no big whoop for the government. I mean, or, that's sort of, that analysis, and that's what we're talking about when we talk about the injunctions and the stay, and then people fight about that, right? If the lower court says, yeah, you're right, I'm not going to let it go into effect, and then someone appeals and someone appeals. So what Ben just described was the appellate process on the injunction. So these cases are going to take a while on the merits, meaning on the actual substance, to work their way up the system. So we're still going to see more decisions come down.
And I'm sure more policies.
And I'm sure more policies.
Yeah. So, and also the more recent thing that yesterday, I think it happened. So
Yesterday?
maybe
Day before yesterday?
Monday.
Seems like yesterday.
Anyway, so there was this change in policy where, yes, was this change in policy that Maria had talked about earlier, where people, so typically what had happened is that if people passed the credible fear interview in the past, they kept being detained, and they could ask an immigration judge for a bond in some circumstances. What we saw really frequently too is that they were given a notice to appear and just like allowed to appear in front of an immigration judge to present the rest of their cases. But in January of this year, the Department of Homeland Security issued something called the Migrant Protection Protocols, which people refer to in our wine as Remain in Mexico. The stated goal of then Secretary Nielsen was that the Migrant Protection Protocol was a historic action to confront illegal immigration. Now, keep that in, so what she was purporting to say is that if people are able to come to the United States, they don't show up for court hearings. Those statistics are not true. I mean, the vast majority of asylum seekers show up to their immigration court hearings. But so that was the stated goal, was that they didn't want people to be in the United States throughout the pendency of their immigration court hearings. They wanted them to go to Mexico, where they would either wait for their day in court. I mean, we had no idea how it was playing out. Like, we had our colleagues there where, like, I was following, like, their Twitters and everything, and, like, you just had no idea. Like, it was the day of someone's hearing, you have no idea if they'd be able to come back for their hearing. The government said in court that they didn't have addresses to reach the people in case there was a change of their hearing. It was unclear how we were going to be able to, as attorneys, be able to represent people in Mexico. There were significant problems. But anyways, so recently, on April 8th, yesterday, the district court, the Northern District of California, wrote that statutorily, that Congress did not authorize people that are not from contiguous countries, from Mexico or from Canada, to be returned to those countries. So like, you weren't authorized to return someone from Guatemala to Mexico and just have them there. There's no statutory authority for that. They also held that there were not sufficient protections to allow for these people as they're waiting in Mexico, that it was dangerous, that the process of being able to escape harm in Mexico was insufficient with due process. And then all this goes back to the United States legal obligation to protect people from harm. Like, to just return someone to a place where they might return harm does not comply with the protections of the Migrant Protocol, or not the Migrant Protocol, the Refugee Protocol. And so this will go into place on Friday. Plaintiffs must be allowed to re-enter the United States, and the program must cease. I'm sure this will be appealed to the Ninth Circuit if it hasn't been already, so we'll see.
Yeah, so the next step will be, right, there's probably there's an injunction, and there's going to be an appeal of the injunction, or there will be agreement. Maybe the parties will agree to not have certain portions of it. go into effect. But basically, people today, tomorrow, Thursday, they can be sent back to Mexico. On Friday, no more. So I think the things, to think about is really all of these policies that we've talked about, every single one of them has been declared to be unlawful. Now, the travel ban, as you know, was ultimately upheld. It was in a significantly different form than when it was first issued, however. There was a lot of modifications made. And there's other cases that we're not even hearing about and not talking about today. I mean, one of the most significant, I think, and that supports the proposition that asylum seekers are not inherently unwilling to attend their hearings is not only are the rates very high, of all people in removal proceedings or deportation proceedings, the ones seeking asylum have the highest appearance rate, which makes sense because they're scared to go back. They actually want to go to the court. But because they go through this, even more now, but when we were seeing in family detention, they go through a process where they have to talk to this agent, this asylum officer, then this ICE officer who gets them on the bus, then talk to the Office of Refugee People, then maybe check in when they get to Idaho, their home destination, they check in with ICE there. And all along the while, people are telling them different things or not telling them things. And really, the system is so disjointed that there's no one unifying notice to individuals. You have to file your asylum application within a year. And the appointment to go check into ICE is different than checking in with the court. People don't know that. They don't get that. And so there was a class action suit and a class certified that was everybody during this time period who purportedly didn't file their asylum application within a year, get to file it today, even if they've been here longer than a year. Why? Because factually it had been established that it was the notice given to them about their obligation was not reasonably calculated to actually give them notice of that fact. So just things to keep in mind there. This is our contact info. I don't know that we have a ton of, we have 15 minutes or are we done? Do we have 15 minutes? It's 2:30.
Yeah.
Okay, great, perfect. So we're happy to take questions from y'all and finish up. Anybody? We can talk forever, really, watch out, it's bad.
Does anybody have any questions? Okay.
Sure.
Given that so many of these people are probably not bilingual, and what does your organization and other organizations do as far as you have an interpretive staff there helping? I noticed that you have this, but I wondered how many people would actually be able to understand something like this if they're maybe even illiterate in Spanish. So could you address competency in what they understand?
We can't afford and don't have the money to pay for lots of translators. We use their support systems. The IRC, sometimes we call IRC to see if they know somebody who speaks a certain language. It's tricky though, because the communities, each community, they're small communities, right? So you don't necessarily want someone who's gonna see you at the grocery store that you go to church with knowing your business. So really what I think people try and do is we're trying to put together a list of volunteer interpreters on all kinds of languages for all kinds of things. And there are language lines that you can call. They're not great, but even in, I think even in the government processing for the indigenous Guatemalan languages, there were people who sat there not knowing what was going on for a month. Just nobody, they couldn't even find, they were I don't know what this language is. This Mom? Is this Quiche? No, it's some other language, and I thought I knew a lot of, at least what they were called. No, it's a huge deficiency. And we're not doing, we're doing the best we can, but it's not enough, for sure.
Ostensibly, there are folks that don't know what is
Oh, yeah, for sure. And then they're relying on other people, sometimes people helping them, but then they end up charging them, yeah, difficult. Anybody else?
Tell us a little bit more about the unaccompanied minors. You said there was an increase in them. So are these the children who are trying to avoid forced marriage or being targeted because of their sexual orientation? And what do they do? How does it look different for a minor to navigate this system?
So an unaccompanied minor, they're going to have lots of different cases. They're often fleeing the same persecution, or that don't have parents in their countries, unfortunately. They have a special process. They're entitled to certain protections under the TVPRA, but I can't remember how it's.
Trafficking Victim Protection something act.
But this is another thing that's happened. So they, under that act, they're supposed to have the ability to apply with an asylum officer, which is less adversarial for their protection. What we're seeing is that when someone turns 18, the government is taking the position that they're no longer deemed unaccompanied minors. Even our position would be like, if you're legally deemed an unaccompanied minor at the beginning, that you should be entitled to those protections. But the government is saying, no, once you're 18, those protections end. So we're seeing a lot of times where people will turn 18 before they get the benefit of having an asylum officer rule on their case, so then they just have to go right to the immigration judge. Also, I think people are seeing that if someone turns 18 while they're in Office of Refugee Resettlement custody, that ICE will actually go and pick them up the day they turn 18 and bring them to detention centers.
Kids are like 17 and 16, and they know. They're like dreading their birthday. They know when that happens, if they're close, they're going to get picked up and sent to an adult detention facility.
And then I think, part of the reason why there's been this increase in minors in custody has to do with more minors coming, but it also has to do with how long it's taking the government to find a guardian release. I've actually spoken to people that can confirm this for me, that this process that used to take sometimes 2 weeks is now taking, I've had people in Idaho where it's taken 6 or 7 months for them to be reunified with their child. And all this slows down the process, and there's many reasons why there's more unaccompanied minors in custody, but.
The other, thing that I've observed, I think Ben's probably done more of those types of cases, but what I observe about the clientele, even if they're older now, is it's sort of like the confrontation of such difficult adult things from such a low age, especially if they never had parental protection. It's like they both grew up quickly, but didn't grow up really. Like the decisions that are being made are not necessarily like what you would call mature decisions informed, because they didn't have guidance of some, so you see, or you might be talking to somebody who can't, didn't have a parent since they were 13 and now they're 20, and they still sort of there's certain ways they are very childlike, and then they go in front of the judge and you're already intimidated, people are up there speaking a language, talking about laws you have no idea, and then there you are, you're just in this formal process. It's just they just I've noticed they just appear different. The same with the indigenous folks, I think.
Yeah.
Just have a very different sort of presentation and limitation.
No one gets in immigration court proceedings. There are no public defenders, which is one of the goals why we're doing this, and that includes minors. So minors don't get an attorney unless they can find one. So one of my lasting memories of being in Texas is I knew the people that were providing the volunteer services through a place called Probar at the border. And I remember going to court, and there would be hundreds of kids, and one attorney shepherding these kids around and appearing with them in court, and it was the visual of it was something that I was really.
So I guess in closing, then I just will give a couple more bits of information about what we're doing. So we're located here in Boise. We are doing both educational services and court representation to the extent that we can do so free and low cost. We are relying on a lot of volunteer help. So particularly folks that have language skills. We've had a group of people come back more than once that we've trained on how to help us do the intakes on our big intake days. We start the day with a presentation, either about what happens in immigration court, or if you're not in immigration court but you're interested in how people legalize their status. So we do a presentation, and then after that, the presentations are free. After that, individuals can decide if they would like to have a one-on-one consultation. At that point, legal assistants and volunteers help gather the biographic data, and then we go into the meetings and help kind of evaluate what we can do for them. The other big goal of what we're trying to do is educational things like this, raising the competency around immigration discussion, around what's really happening, because it's very hard to have any sort of really accurate discussion about immigration law when you're doing it in little sound bites that you hear on commercials or those kinds of things. And we want people both in the affected communities, if you know folks in affected communities that would like presentations, if you are a teacher or a social worker and you think that your profession needs this information, needs to understand what's happening with your non-citizen or mixed family clients, we are happy to provide, to work with you to do educational services. And lastly, for folks that they want to be supportive, for people who want to be supportive and want to talk more competently about these issues, then we're doing things for the general public as well. So we welcome your support, whether it just be coming to events or engaging with us on social media. If you would like to volunteer and you don't know how, you just send an email to volunteer@Immigrant Justice Idaho, or that email, and we have some more information that you're welcome to pick up. So thanks for your attention and thanks for being here.
Thank you.